Well, hello everyone, and welcome to One Civil Law. I hope you're having a good night as always, and we are here with an oral argument react. Today we will be reacting to oral argument in a case dealing with whether or not women should be required to sign up for the draft. The United States has not had a draft in this country since the Vietnam era, yet the draft itself remains. Men have to sign up for the draft when they turn 18, and failure to do so incurs some penalties. Most notably, for most men, the most serious penalty is inability to get certain federal loans and certain federal grants. Of course, federal employment as well as other federal benefits may not be available, but the one that is most serious and most notable to most men is the inability to get certain federal financing and certain federal student loans for failure to sign up for the draft. And the draft boards themselves continue to exist despite the fact that there is no draft. And the reason I know that is because I know a guy who is a member of the draft board. So the draft board itself continues to exist despite there not being a draft since the Vietnam era, and men still have to sign up for the draft. So the question is, should women be forced to sign up for the draft? And this was recently decided by a district court in the Fifth Circuit. In this case, was a district court coming out of Texas, which said that yes, women should be required to sign up for the draft. And the logic of the district court is reasonably simple, all things considered. There might have been a time and a place when it made sense not to have women sign up for the draft, but through a variety of changes that the military has done over the years, women are now eligible for all combat roles, including some Marine service, I recently learned. So they can do anything, or they can sign up for any kind of service. And so while maybe they might be different in some ways, whether or not they should be eligible for the draft, because they can serve in all combat roles, is of course a thing to consider. And if we want equality between men and women, maybe women should be forced to sign up for the draft as well. I mean, it's not that big a deal. You just have to sign off a piece of paper when you turn 18, but still, maybe they should be forced to sign off on it too. So that is the question. The Fifth Circuit, the district court said that because of these changes that have been made where women are becoming more and more integrated over the years, that any sort of rationale for women not having to sign up doesn't make sense anymore. And the Fifth Circuit Court of Appeals, which is the court that has heard this appeal, has heard the appeal but not yet rendered a decision. So tonight we're going to listen to the oral arguments in this case. These oral arguments were heard at Tulane Law School, which is kind of cool. So the Fifth Circuit Court of Appeals decided to hear the actual case at a law school. Not in a courthouse. They heard it at a law school. So the image that we're going to see, because again, there's no video, because it's federal court, there's no video. So you only get one image, and that's a picture of Tulane Law School. Because it's either that or looking at me the whole time. So we're going to listen to that. So here's basically what I would expect the arguments to be from the two sides. From the people who are saying that women should be forced to sign up for the draft, this is the argument from the district court, and the argument I just highlighted. Men have to sign up for the draft. Normally, in normal law world, when we deal with discrimination on the basis of sex, we use intermediate scrutiny. So it has to have a substantial governmental interest, and it has to be narrowly tailored, or it has to be tailored to that purpose. And whatever rationale might have been at one time is no longer the case. So we can't pass intermediate scrutiny review. There might have been a time and a place when it made sense, but it doesn't make any sense. In other words, the federal government has, through its policies, undercut its own logic. So that would be the position in favor of women should have to sign up. The position against will have to be, first of all, precedential. But the precedent is going to be, again, undercut. But there is some precedent that says that women don't have to sign for the draft, but the factual underpinning has changed since those. So first is going to be precedent. And second, the second arguments will be, yes, it will pass intermediate scrutiny review. And second, even if it doesn't, the military is different. Congress has so much power over the military and regulation of the military that it doesn't have to meet this standard. It can choose to have the regulation at once, and this is a question of policy. So if I were a betting man going into this, I would expect the district court to be reversed. I don't say that because I don't think the district court's decision wasn't reasonable. I thought it made a lot of sense. I thought it was reasonable. I thought the analysis made a lot of sense. But if you asked me, I think at the end of the day that Congress has so much power over the military. The military is this thing that only Congress has the ability to do. They don't really have to make intermediate scrutiny. Congress is the one that invents these rules on discrimination anyway. So if they don't want to follow their own rules when it comes to the military, they don't have to because they're Congress. So they don't even have to meet these burdens. And the military operational need is still present. Even though women can sign for everything, they are not in the end equally capable. And so it wouldn't make sense to have women sign for the draft. The administrative costs, the compliance costs, the dealing with it, the women wouldn't be able, and so forth and so on. And these are ultimately policy choices that Congress has to make. So that would be the position I would imagine from the United States government. But of course, we're going to hear from both sides as they may make their respective arguments. But I think that the United States position is probably a little bit better. And I would expect, especially based on the precedent, again, I think it's been a little bit mooted from time, but, precedent is precedent. And so I think that the rationale is going to be a little bit undercut. So that is where I think we are sitting. $5 from Nuvi. Thank you very much. Obligatory ad block fee. Thank you very much. Also, conscription should be banned altogether. Maybe it should, Nuvi. Maybe it should. But that's not where we are. And so we will deal with this one thing at a time. So let's listen to this. And again, apologies in advance. This is audio from a court, and the audio isn't perfect. I've tried to fix this a little bit in the sound processor, but I might have to manually adjust the audio levels. So if it's not perfect, I apologize, but court audio is notorious for being a little bit iffy. It was very quiet. I had to artificially raise the level and so forth and so on. So I'll play with the volume knobs and try to keep it at a reasonable level, but we're going to just have to deal with it what we can because it's court audio. So, leaves a little bit to be desired. Again, this is Tulane Law School because the Fifth Circuit Court of Appeals decided to have the argument at Tulane Law School. So that is the picture you get a copy of. And so let us go back to the start of this oral argument and listen to what they have to say. Let's get started.
Thank you. Ms. Murray.
Thank you, Your Honor. May it please the court. Claire Murray on behalf of the United States. This is a case about deference to the Supreme Court and to Congress. The question presented in this case has already been decided by the Supreme Court of the United States. In Rosker v. Goldberg, the Supreme Court held, quote, Congress acted well within its constitutional authority when it authorized the registration of men and not women under the Military Selective Service Act.
All right, but when they held that, they go into some detail that at the time, women were prohibited from combat, and that seemed to be sort of the rallying point in the majority. Of course, there are vigorous dissents by Justice Marshall and others, as I recall, in the case, but seemed to be a seminal point about women prohibited from combat and some other factors as maybe making the difference in terms of the way the court came out. So having said that, assuming that's correct, is that such a difference, i.e. that, of course, now women are not prohibited from combat, et cetera, et cetera. So in other words, Rosker definitely says what it says, but is the fact, the reality of women in combat and everywhere else, within certain, is that a factor that allows distinguishing? I mean, I know what the Supreme Court says about it. It's their job to decide what doesn't apply and so forth, but undeniably that the court spent a lot of time on the women are prohibited combat, etc. You see where I'm going, and there's figures of sense. So since you lead off with roster, just help me understand, is that a meaningful difference, or it's just a fact in the analysis, but doesn't mean that roster doesn't apply? It's a long way to ask a question.
The fact that one of the Supreme Court's justifications has changed does not mean that its holding has changed.
Okay.
So by its very terms here, we have the same claims, the same claim which is a due process claim sounding in equal protection. We have the same statute, the Military Selective Service Act. None of that has changed, and by its terms, the question presented in Rosker is the same as the question presented here, and the court's holding is the same. Now, it's true that one of the court's justifications, maybe its main justification, has changed. But the Supreme Court has been very clear that when an underlying justification changes, only the Supreme Court has the, quote, prerogative of overruling its own decisions. That's Rodriguez de Quijas. And that's true even whereas here, the underlying justification that has changed is not a bit of case law, but is a fact. And so for that proposition, I would turn the court to State Oil v. Kahn, which is an antitrust case, where the court switched from a per se rule to a rule of reason, overruling a prior case, and it looked at, quote, changes in economic realities and changed circumstances and the lessons of accumulated experience, in part. And nonetheless, what it did was praise the lower court for applying its previous precedent rather than overruling its previous precedent.
And how many years has Congress had since women were allowed in combat and have done nothing?
Women have been fully integrated into combat units or allowed to join all combat units since January of 2016. But I wouldn't say that, so since January of 2016. And so that's been 4 years. But I wouldn't say that Congress has done nothing. Congress has done two important things. First, Congress almost changed the law. So Congress went through the amendment process within the National Defense Authorization Act and came close to admitting women into
It almost did something.
It almost did something. But then in lieu of that almost doing something, what it did was it established a commission. So 2.5 years ago, it established a commission to study this question. That commission is due to produce its report to Congress this month. It has been charged with doing hearings and listening sessions and talking to the...
Is it in fact going to submit it this month?
This is outside the record, Your Honor, but yes, the commission has announced a few days ago that the report would come out March 25th. And presumably what that will do is kick off the same process that Congress went through in 1980, which was the last time there was a sort of big change in circumstances, which is to have floor debates and hearings and committee debates. And it would really short-circuit that entire process for this court to get ahead of that process and hold that it is unconstitutional for Congress to maintain the status quo while it deliberates about this question.
All right, so far we've got two basic ideas. We got the precedential issue, which I mentioned, and she says you can't overrule the precedent from the Supreme Court, even if its underpinning has changed. So that precedent is precedent, even if the rationale doesn't make sense. That's probably true. That might be a basis alone to render this decision. And she also says that this is a matter of policy, and Congress is getting right on that. They are working on this issue, and there's no need to jump ahead of this. So it is a classic conservative philosophy, deference to the legislature. So that's what she said in her opening line. In her opening line, she said deference to the Congress and deference to the court, and she's addressed both those points already. So she's sticking right with her themes, and so far she's off to a really promising start. Yeah.
Thank you. Set, Ms. Murray.
Thank you, Your Honor. May it please the court. Claire Murray on behalf of the United
And I restarted the audio. That's just great.
Act
Thank you.
and came close to admitting women into
It almost did something.
It almost did something. But then in lieu of that almost doing something, what it did was it established a commission. So 2.5 years ago, it established a commission to study this question. That commission is due to produce its report to Congress this month. It has been charged with doing hearings and listening sessions and talking to the...
Is it in fact going to submit it this month?
This is outside the record, Your Honor, but yes, the commission has announced a few days ago that the report would come out March 25th. And presumably what that will do is kick off the same process that Congress went through in 1980, which was the last time there was a sort of big change in circumstances, which is to have floor debates and hearings and committee debates. And it would really short-circuit that entire process for this court to get ahead of that process and hold that it is unconstitutional for Congress to maintain the status quo while it deliberates about this question. Even if Rosker doesn't control, which we think it does, but even if Rosker doesn't control, it is very clear about the fact that judicial review in the military sphere is extremely deferential. This is the context where Rosker said judicial deference should be at its apogee. Rosker obviously resists putting a label, a tier of scrutiny on the level of analysis it requires, but its analysis is interesting in three respects. So first, Rosker looks not just at Congress's express justifications, but also to what Congress may quite rationally have believed. That's the Schlesinger formulation. And obviously that's not something you see in an intermediate scrutiny context. And Rosker embodies that. So the court in Rosker looks not just to the justifications that Congress put forth in 1948 when it passed the Military Selective Service Act, but also to what Congress did in 1980. Second, Rosker makes clear that courts may take into account administrative problems. It says it's not for this court to dismiss such problems as insignificant in the context of military preparedness and the exigencies of a future mobilization. That's not something that occurs in an intermediate scrutiny context, as we know from Craig v. Boren, but it is something that the court can look at here. And third, Rosker makes clear that Congress is not required to do the same level of close tailoring between means and ends that it would be required to do in an intermediate scrutiny context. So probably the clearest illustration of this is the Goldman v. Weinberger case.
So I just want to make a quick note there. When she said there's not same means and ends, they'd have to do an intermediate scrutiny case. So as I was pointing out in sort of the preamble as the introduction to this stream, intermediate scrutiny is what we normally use. And so she just made a line there basically saying, yeah, the normal analysis we normally use in intermediate scrutiny doesn't apply in this context. So we're in some sort of different domain because of the military context. And she referred to that earlier as well. I'm just making a point of it because she mentioned the intermediate scrutiny element that I mentioned specifically. And so she's going to this idea that in the military context, we do something different because the nature of the military is something that the courts should stay further out of than in other domains. The military needs to be able to military, and the courts are ill-equipped to military. So letting the Congress and the executive branch military is what they do, and the courts should be loath to interject themselves. So far, pretty good from the United States Attorney. It's very simple, clean. It's not exceptional in terms of an argument. It's not blowing me out of the water. It's kind of what I expected to hear, but doing a very good job presenting it. This is kind of the line. This is kind of the lines that I'd be presenting, as I sort of was alluding to. So this is kind of the same sort of arguments I'd be making if I were making it for the U.S. Attorney. So, nothing exceptional. It's like not something that blows my mind. Like, oh, I never thought of that, or this is outside my ability. I'm like, okay, this is something I understand, and it's not disappointing. It's right exactly where I expect it to be. So far, so good.
Which is a case where an Orthodox rabbi who was a clinical psychologist on a military base wanted to wear a yarmulke. This is a pre-employment division versus Smith case, so strict scrutiny applies. We're effectively in a RFRA world at this point. And nonetheless, the court is unmoved in that case by the fact that the government is unable to produce any studies showing that there would be harm to military esprit de corps from yarmulke wearing, whereas Mr. Goldman has a number of studies. They're unmoved by the fact that the government doesn't look at making exceptions for Mr. Goldman. And Rosker is the same way. So in Rosker, the court is not swayed by the fact that there were, at that point, 80,000 non-combat positions that could have been filled by women even before women were admitted to combat. And if you apply those sort of three aspects to the deferential review here, it's clear that the male-only registration requirement survives constitutional muster. So Rosker itself, we look at means and ends. So in terms of ends, Rosker itself found that the government's interest in raising and supporting armies qualified as a, quote, important interest. So even under that higher intermediate scrutiny standard, Congress's end is important enough. So then the question for us is just
right. So in intermediate scrutiny, you need to look at what you're trying to do and the why you're trying to do it. So what is your rationale? So in intermediate scrutiny, you need an important interest. That's a term of art, as opposed to a compelling interest in strict scrutiny. So in intermediate scrutiny, you look to an important interest. So not just a rational interest, not a compelling interest, something in between, an important interest. And they're like, yeah, the draft is an important interest. And I'm like, yep. First half of the strict scrutiny analysis is easy, no problem, without breaking a sweat. Yes, the draft is important. The military is important. Protecting the country is important. It's like one of the things that Congress needs to be able to do. So yes, we're first half of your intermediate scrutiny analysis, no problem, not even breaking a sweat.
Just whether Congress may quite rationally have believed the government's interest would be served by the male-only draft requirement, or at least by maintaining the status quo while Congress studied the issue, which, as we've discussed, it's doing right now. And my friend's position is that there's no way that Congress could rationally have believed that its ends would be best served by this position. And we think there are several reasons why that's not true. So just stepping back, The point of a draft is to quickly raise a lethal force to defend the country in an emergency. The National Defense Authorization Act says that it's for the draft is for replacement combat troops. So it's for times when the front lines have fallen and we need new frontline soldiers. Given the physical differences between men and women, my friend has not shown that Congress.
Okay, so the U.S. Attorney believes that there are physical differences between men and women. Just want to take a note. The U.S. Attorney says, yes, there are physical differences between men and women. So at least one person is still willing to say it out loud.
Could not have rationally believed that a randomly selected pool of women would be less likely on average to produce, the same number of combat-ready troops that a randomly selected pool of men would have. And, that is alluded to in DOD's 2017 report in the record. Secretary Carter's implementation memo for integration of women into the service cites another reason, which is that Marine and Army studies show that women in combat are more likely to sustain injuries than are men in combat, which is why DOD's 2017 report to the Commission flags concerns held by some that conscripted women would have a lower chance of survival if forced to serve in direct ground combat roles. So these are all reasons that Congress could rationally have wanted to preserve the status quo while it studied these important issues. And then if we turn to those administrative costs and burdens that the court is allowed to consider in this area, if there is in fact a lower yield from an average taken off the street pool of young women as opposed to a taken off the street pool of young men of combat ready soldiers, that would make it more difficult to allocate training resources effectively and efficiently, which is something that Rosker specifically looks at. So you can think of it in terms of they would need more boot camps, they would need more trainers, just because your yield is lower, so you have to start with a larger pool.
So that's an interesting idea. So the idea here is that it puts a burden on the military trainers, and you need more of them because women have a lower throughput. Fewer women would be able to make it through boot than men. So you'd need more trainers to train the pools of women than you would the men. And you get a lower result, so you get a lower yield. So out of the name of efficiency, it makes sense to only get men because men are better at fighting than women. Yeah, that's okay. The U.S. Attorney still believes in such things. You go, girl.
In addition, conscripting equal numbers of women would dramatically change the gender balances in the forces right now. Right now, since 2016, all combat positions are open to women, but they are not filled in equal measure by men and women. Whereas if we had a draft that all of a sudden had an influx of women and changed those percentages, there are a number of just sort of ticky-tack things that would have to change. So this is sort of prosaic, but if you look at equipment sizing and supply are two of the things mentioned in the record, right? So if you have a small number of women in combat, you might have a small number of combat-style equipment that are tailored to women and to their specific size and strength levels. If you all of a sudden have an influx of women to create parity, you need a huge number of additional sets of equipment sized to women. Similarly, there can be issues in lodging, issues with respect to bathing facilities. All of these are reasons why when the military first integrated women into the military more broadly and also into the into combat more specifically, a multi-year implementation plan was envisioned. That's very different than the timeline you see for a draft, for conscription. In a conscription context, you're looking at a matter of days, right? The DoD report talks about in terms of how many people can we raise in 100 days. And as I said, Rosker says that you can take these things into account. Going back to the sort of Rosker point, two other cases I would turn the court to are just Justice O'Connor's, who is the author of State Oil's dissent in Roper, and also Judge Stahl's opinion in Elgin. Judge Stahl in Elgin, it's sort of an intermediate point in terms of changed circumstances. So the Elgin is the same challenge brought here. Most of the court resolves the case on sort of procedural grounds that are not relevant to us. But Judge Stahl reaches the equal protection claim. This is in 2011, when women are allowed in some combat positions, so submarines, for example, but are not allowed in all combat positions. And what Judge Stahl says is
This is a little bit of a side note about the speaker. I like what she's saying in terms of her analysis, but she needs to work on her presentation. She doesn't sound as confident as I would like. Her legal analysis is fine. Her research is fine. Her points are good. But I wish she was delivering them with a little bit more confidence. She sounds a little bit unsure of herself. And it's a bit of an unfortunate reality, because what she's saying legally makes perfectly valid sense. She's got really solid middle of the road legal analysis that's relying heavily on precedent, heavily on congressional deferment. She's making some pragmatic points that are a little off point for my taste, but that's a little bit more tastual. So it's a little bit off point, but it's workable, and there's nothing wrong with it. It's just not quite how I'd go about that particular aspect. She's citing precedent. Now she's going to some other cases and support her position, but she's not delivering it with the level of confidence. She sounds a little bit unsure of herself. And so, yeah, I wish the U.S. attorney was a little bit more confident. She obviously is a smart woman, so you should feel confident. You should feel confident, U.S. attorney. You've got this down. You've got it. Just go in there and show them who's boss. You can win this, and you're doing fine. I just wish she was shows a little bit more machismo about it than she's showing. In my humble opinion, her delivery needs a little bit of work.
Look, there's been a dramatic change of circumstances here, but, quote, it would not be for this court to determine what, if any, impact these developments had on the continued vitality of Rosker. That's a task left solely to the Supreme Court.
Everything you've said here in this university law school's moot court would have been wonderful, but you just hit the question. Isn't the Supreme Court the only one that can reverse its prior judgments?
That's right.
This judge sounds like he needed to retire 10 years ago. Again, what he's saying legally is fine, but he sounds like, isn't it true that there's this body that meets, I think, in Washington, and their Supreme Court, I think, and only they can reverse their decisions. So, yeah, okay, let's press on.
That's why we think that Rosker controls, and that should really be the end of this case.
Well, all of this other is interesting, but we'll see what counsel opposite says about the Supreme Court having exclusive the right to reverse itself.
Thank you, Your Honor. Then maybe I'll reserve the rest of my time for rebuttal. Thank you.
Okay, thank you. You've reserved your time.
All right, so she's done at 12 minutes. She has 15 on appeal, and she kind of lost steam, which is perfectly fine. And also, she left on a really strong point. She had made this point earlier, but she left on the strong point. So I like this taking of time. It sounded more like an audible. It sounded more like an audible in a football sense of the word, like she's making a decision on the field rather than like it being planned to be at this point. So it sounds more like an audible that she says, "Oh, I've kind of said what I need to say, and I just came off on this strong point about only the Supreme Court can reverse themselves, and so I might as well just reserve my 3 minutes." So far so good. She has really solid legal foundation, really solid case law. So it'll be interesting to see what the other guy says. He's got a problem. The other side has a problem. He has to convince the Fifth Circuit Court of Appeals that they can rule in his favor. So that is his immediate problem. He has to figure out how to tell the Fifth Circuit that, yes, you can rule for me. If she's right and there's a Supreme Court case and it is only Supreme Court can reverse themselves, then there's only one decision. The decision is to reverse because the district court got it wrong. And let the Supreme Court unreverse them if they're going to do that. Like, they can only make one decision. So the other side has to say, yes, you can rule for me. So the other side has to get themselves out of this hole. So how do they make that issue? Let's listen and see how they get out of this hole.
All right. He said, Mr. Angelucci.
Good morning. May it please the court, I am Mark Angelucci, counsel for National Coalition for Men, James Lesmeister, and Anthony Davis. I would like to first begin by discussing the stare decisis issue because, Your Honor, you just raised it now, so I think it's on point. That is simply not true. What's being argued here. It is true that only the Supreme Court can reverse its own decision. But as some federal courts have already explained, there's a difference between following a decision and following a precedent and extending a precedent when new circumstances have changed that are significant. In this case, the ban on women in combat has been completely lifted, and that was the primary, if not the sole, basis on which roster was decided.
But that doesn't.
Ooh, that's mixing the issues, and the attorney, then the judge is about to smack him down hard. The judge is about to smack him down hard, but I'm going to smack him down first. No. Those are totally different things. You just made two completely different arguments. And the judge is about to smack him down, but I'm going to get there first. There's a difference between upholding the precedent and extending the precedent. You're correct, there is. And then he said, and this has undermined the precedent. No, that's not the same thing. If we are following the precedent, if we're within the bounds of the precedent, there's only one decision. If we were extending the precedent, if it were a new situation, then yes, we'd have to extend it or not, right? Because the Supreme Court only speaks as far as it speaks. So if we were extending the precedent, then yes, we'd have to make a decision whether or not to extend or not. And one of the reasons we might extend or not would be based on the underpinning rationale of the Supreme Court decision. If it's been undermined and we're looking to extend, then we'd say, okay, there's no basis to extend. But that is pre-basing the question. And the judge is about to call him out for this. It's like, no, that's not the same thing. You said that we don't have to extend. You're right, we don't have to extend. But if we're in the same universe, we have no decision. We have no choice. We have no choice. Our decision must be to reverse. And the judge is about to whack him upside the head with this because he just made a no. So let's watch the judge smack this guy right upside the head with this inconvenient fact.
It doesn't free us to engage in anticipatory overruling, does it?
It's not anticipatory. It's looking at the ruling. It's still applying roster, but under the new circumstances.
No.
It's not changing roster.
No.
Roster is still alive and well.
No.
In a circumstance where women are not allowed in combat, then there's a basis under heightened
The Supreme
scrutiny.
Court has made clear that even if the underpinnings of a case have been undermined, so even if the foundations have become what the court has called a wobbly or moth-eaten, we're still bound to follow it, are we not?
I don't agree. And one of the cases I would refer to is one that's in fact cited by...
I don't agree. This guy had better be a genius. And he's not a genius. I am quite convinced. I am far enough into this oral argument to know that he is not a genius. Because he's like, no, I don't agree. It's like, you better have one hell of an argument that you're going to make about, no. As it turns out, you've completely misread the law because of this other decision that you're not paying attention to, which says exactly the opposite. Which I'm pretty sure doesn't exist. So unless he's about to big brain this, he has to big brain this, or he's about to die. He's about to die. Let's watch his case die in front of our eyes, shall we? Let's watch it just crumble into dust and nothingness. Okay, this will be fun.
By the Selective Service, and that's Agostini versus Felton, 521 U.S. 203. In that case, the city of New York was sending, and I'll be very brief in the facts, but the city of New York was sending public school teachers to teach in parochial schools. Some taxpayers filed a taxpayer lawsuit to challenge it under the Establishment Clause. The trial court sided with the school board. The Court of Appeal reversed, and the Supreme Court upheld that reversal, and so there was that sided with the school board, and then the Supreme Court upheld the reversal. So there was an injunction on the school board from doing that. So the school board changed and started having these teachers teach parochial lessons within the public schools instead. Then the school board sought relief from the injunction. The district court cited.
Okay, no. You have not proved your point, counselor. You have not proved your point. Let us review what he just said for all those of you who didn't pick up on it. He said there was a case in which public school teachers were to be sent into private schools for the purpose of religious education. And the Supreme Court said no. All right? Then the school board said, aha, we have a different idea. What if they offer religious institution within the public schools? Now, is that the same thing or is that a different thing? Well, it's a different thing, right? The logic of it may or may not extend. You'd have to look into what was going on and exactly why. And you have to look into whether or not to extend that logic or not. But it's not the same thing, right? If the school board had said, screw you, Supreme Court, we're sending our teachers into the private schools anyway, or we're sending them into different private schools, or maybe we're sending them to Islamic schools instead of Christian schools, or something like that, that would be on point. But that's not what the school board did. The school board said, okay, fine, you say that we can't send our teachers into private schools. Well, what if we just don't do that? What if we instead keep them here? Now that's a different legal question, which raises potentially different legal issues. And we could extend or not the decision from before. So we're not in the same universe. We have to make a decision as to whether or not to extend or not. And that would go into the underlying logic of the basis of the decision. The Supreme Court came to an end conclusion. The end conclusion is no, you cannot send your public school teacher into a private school. Well, why? And here they lay out the rationales. And then a court saying, well, can they teach religious in the public school? They would look and see if those rationales are different or the same. And they'd say, oh, they're the same, therefore the same result. Or they're different. Oh, different result. Or, oh, it's a mix, and I have to think about it. But I can imagine those coming out the same. Those are not the same question. And so his case just went... His case is dead. It's over. It's all over. It's completely all over. His bombshell precedent on why women should be forced to sign up for the draft. His bombshell precedent for why women should be forced to sign up for the draft was public school teachers wanted to teach about religion in public schools one time in New York. Yeah, that's definitely going to win the day. Those two things sound like the same universe. Let's continue.
Against the school board, and it went up to the Supreme Court, and it was reversed. And the Supreme Court stated, and I quote, in Rufo versus Inmates of Suffolk County Jail, we held that it is appropriate to grant a Rule 60b-5 motion when the party seeking relief from an injunction or consent decree can show a significant change in either factual condition.
Also, it's completely off point because, are you ready for this, kids? Are you ready for the other reason it's completely off point? Because the Supreme Court was reviewing the case. So in that case, the Supreme Court issued an injunction, and the court, they wanted to do something else. And the Supreme Court is the one that's reviewing it. So the Supreme Court can overrule its own precedent, modify its own precedent, because it's the damn Supreme Court. Yeah. The Supreme Court issued an injunction. They did some other stuff, and they said, okay, we're going to withdraw the injunction we put in place because there's been a change, because we're the ones reviewing it, because we're the court that issued it, because we're the Supreme Court. So it's completely inappropriate to this situation. No, it's not true that only the Supreme Court can overrule itself. And for authority of why it's not true that only the Supreme Court can overrule itself, let me cite you a case in which the Supreme Court was overruling itself. Well, I'm sold. Yeah. This is the greatest legal argument of all time. The Attorney General of Oregon had more going for her than this guy.
Or in law, a court may recognize subsequent changes. And it goes on to describe how courts can, in fact, do that. If there are completely different circumstances, and in fact, another case recently in New Jersey held the exact same thing. That was the Kyle LaBelle case, where a woman, and I cited it in my brief, where a woman is challenging the Selective Service, claiming that it discriminates against her because she wants to register. And they made the same argument that only the Supreme Court can reverse itself, and that court stated no. And the exact language said there's a difference between following a precedent and extending it. So they said we're just simply, they refused to throw the case out when the Selective Service filed a motion to dismiss. And they say there's a whole completely different set of circumstances here. What the Selective Service is...
Well, that sounds like the other court just screwed it up to me. That just sounds like the other court screwed it up. There's a completely different set of circumstances here, but the end conclusion is the same. Do women have to sign up for the draft? The Supreme Court said no. That's the end result. And here we're saying, do women have to sign up for the draft? It's the same end result. So you're not... Yes, you're changing the predicate, but it doesn't matter because we know what the end is. And only the Supreme Court can change the end result. So if you were asking a different question, sure, but you're not asking a different question. You're asking the same question. Can women or must women sign up for the draft? The Supreme Court said no. So now you're asking, can women or must women sign up for the draft? Well, I know the answer to that one. I know the answer to that one. The Supreme Court told me the answer to that one. It's no. And another court said, oh, we can just not extend this because of change in circumstances. Sounds like the other court got it wrong to me. There's only one decision to be made here. There's only one decision to be made. This case reversed.
Is in essentially arguing here is that when circumstances change so much that a Supreme Court decision no longer applies because the factual circumstances are so different, a person would have to wait years and years in order to get any kind of civil rights relief because they have to wind their way all the way up to the Supreme Court. And that would just be a very bad public policy to begin with. And
wow, did a court actually say that? Holy shit. That's like the stupidest thing I've ever heard. I mean, you're arguing a policy, but there's binding case law. See, here's the problem. This argument would be fine if there was not binding case law already on point. Like if you ask me in the abstract, if we change the underpinnings of the case, should we still follow the Supreme Court? Now, if you ask me in the abstract, that's a more interesting question. But you're not asking me in the abstract because there's a case already on point that tells me exactly this answer, right? And I have to follow the Supreme Court. And it says that, yes, you have to follow the Supreme Court even if there's been another change. And apparently, according to this guy, Apparently, according to this guy, there was a court in New Jersey who said, we don't have to follow that Supreme Court precedent because if we did, it would be really inconvenient. Okay.
It is not what the cases say that they're citing. State Oil does not stand for that position. In fact, State Oil says, but stare decisis is not an inexorable command. In the area of antitrust law, there's a competing interest.
Also, I'd formally like to retract anything negative I said about the U.S. attorney who went before this guy. Anything bad I said about her presentation style, I would like to formally retract, because this guy is horrible. He's truly, absolutely horrible. His presentation, first of all, his legal knowledge sucks. Hers was on point. And his presentation is just, it's a train wreck. It's a horror show. She had a little bit of confidence issues. She shouldn't feel confident. This guy, he is incompetent. He's horrible. He is absolutely a train wreck horror show. I take everything back I said about the U.S. attorney. You're the most brilliant advocator ever compared to this jackass. Wow. This guy, did they hire Leibowitz? Is that who's doing this oral argument? Did we hire Leibowitz? Is he doing Fifth Circuit oral arguments now? Or something? I mean, Jesus Christ. Hire me. Hire me to do your oral argument. It can't possibly be any worse than this. Lord have mercy.
Well represented in this court's decisions in recognizing and adopting the changed circumstances. None of the cases that they cite are stating that under changed circumstances, lower courts cannot make a different ruling from what the Supreme Court held. That's just not true. And I will leave it at that and move on to the issue of deference. Counsel has, of course, made an argument for deference and a plea for deference. The district court in this case made a sound decision that they have provided no evidence to support deference. They've provided nothing to defer to. The only expert statement or anything of substance in this case presented to support their position is that of the Pentagon report, which sides completely on the side of the plaintiffs in this case, and says emphatically that we ought to be including women in the draft. And it looks at all the different issues that they're raising, like administrative costs and things like that. And it also talks about how this creates both the perception and reality of unfairness in that it flat out discriminates against men. It's sex discrimination that's subject to heightened scrutiny. It's not just a mirage we're talking about here. There are stiff penalties for failure to register, and we know that those penalties, there's 5 years in jail, $10,000 fine, denial of federal benefits. We know they've been applied to men. In the Elgin case, a homeless man who had forgotten to register turned his life around later, and many, many years later was fired from his federal job because he hadn't registered when he was young. These are the kinds of, and there's other cases similar. In fact, there were several.
If we were to put Rosker aside and get into the determination of what level of deference is required, what measure of judicial scrutiny is appropriate.
Right.
I know you argue for something heightened.
Yes.
Because it's sex-based discrimination, as you say.
Yes.
And not rational basis, as the government prefers. But hypothetically, if we were to go the rational basis route, what does that look?
That is the most what I guess forecasted hell hypothetically I've ever heard in my life. Hypothetically, as in there's absolutely no chance on God's green earth we are going to do this. But if we ignored Roscoe binding U.S. Supreme Court precedent, if we were to all collectively have a stroke, how would we deal with the strict scrutiny angle? Let's give you something to talk about that'll make you feel like you're doing something valuable with your time. Okay, let's talk about what happens if we all have a stroke. What's the next step of the analysis? Okay, let's do that.
Look like in real world practice? What does that look like in terms of how a judge would kind of pat down the proffered reasons the government gives? How meaningful scrutiny is that?
Well, given that there are only reasons in the past, and I don't mean just in the Rosser decision, the district court in this case looked at the congressional record and said the primary concern of Congress when they excluded women from the draft was that women were banned from combat. And that the issues that counsel is raising about capacities and things like that were discussed only in passing and very minimally. So they have not met their burden of providing evidence to support the arguments that they're making.
But is rational basis in kind of the military setting any more meaningful or rigorous than rational basis, say, in the economic regulatory setting, which is kind of a judicial shrug, basically?
I don't know that it would make a difference between the military and perhaps the private sector, but the case law is very clear that sex discrimination, even in the military, goes by heightened scrutiny, intermediate scrutiny. In the case of U.S. versus Virginia, it says that intermediate scrutiny, in order to meet that, you have to show an exceedingly persuasive justification for the discrimination. It can't be just persuasive on its own. It has to be exceedingly persuasive. I would analogize that to the clear and convincing standards that a lot of courts apply. It's a very strong standard, and they've come nowhere near meeting that standard, as the district court held. They haven't shown any basis at all. Women are now allowed in combat. We're not here to debate the issue of whether women should or shouldn't. The Department of Defense has decided that they are. So that barrier is gone, and there's no more justification, I would argue, even on a rational basis, for excluding women from the draft. If there's going to be a draft...
I long since stopped paying attention to anything this guy is saying, by the way, just in case you're curious.
And both men and women are allowed in all combat roles, there's no further justification. And the Pentagon has said that very clearly in its 37-page report. The only substantive expert document that we have. We have nothing else other than arguments from lawyers that are very speculative, that aren't even in the record, many of them. There's nothing else that solidly looks at this issue but the Pentagon report. If we're going to have deference, who else should we be deferring to except the Pentagon and the Department of Defense? I don't agree it should be a bunch of lawyers in Congress. It should be the Pentagon. And they have spoken very loudly and clearly. I've submitted that report to the court. I think I would encourage the court, I'm sure you have read it, but I would encourage the court to read it again.
I assume if the commission report due March 25th were to come out forcefully in favor of making the draft applicable to women as well, that you would still press on full speed with your litigation. That doesn't offer you any kind of relief. You would still full speed ahead with your current litigation.
I would, because the cases like Orr versus Orr and Village of Willowbrook are Supreme Court cases that have held emphatically that discrimination by itself causes harm, that discrimination by itself carries the baggage of sexual stereotypes, sex discrimination in particular, and causes non-economic harm to those people that are discriminated against. We know right now that at least 40 states tie selective service registration to driver's license. About 31 of them tie it to school loans, student loans, or to employment. 8 states flat out deny men the right to apply at a state college if they're not registered for the draft. And we know that since, and I've submitted this to the court, since 1993, over 1 million men have requested formal copies of their draft status. And that's the first step taken when you're appealing a denial of benefits. So we're talking about a very large number of men who are directly affected by this, not just ones in the case law like Elgin. So this is very serious. And putting aside those kind of economic damages, there is the stereotype.
Some super chats. $5 from Nuvi. I've got to go. One more super chat because like and subscribe. Thank you, Nuvi. $2.99 from Mandy Amos. Do super chats feed the algorithm? I honestly don't know if they do or not. No, but they feed uncivil law. Thank you, Mandy Amos, for your contribution as always. You know, these arguments would be super duper interesting and all, but there is a U.S. Supreme Court case on point that tells me the answer. And there's another U.S. Supreme Court case on point that tells me even though the factual underpinnings have been undermined, it doesn't matter. The decision must stand. So there is nothing for the Fifth Circuit to do here except follow the Supreme Court precedent. And also his arguments are horrible. And also he's a horrible speaker. And also he sounds, at least the woman U.S. attorney was organized in her presentation. He's unorganized. He's making kind of emotional appeals rather than logical appeals. We are at 24 minutes and 41 seconds into a 35-minute audio. We've got 10 more minutes of this. Okay, let's press on, kids.
That's being spread. And every time we make a young man who turns 18, like James Lesmeister or like Anthony Davis, and tell them you, but not your sister or not your female friends, who some of whom are just as strong as you and are involved in professional sports, you have to register your body as an on-call warrior for the state. We're telling them that they, as males, are disposable. And that male disposability is a stereotype that needs to be fought. Men to this day still don't speak out about their discrimination against them in many other areas like child custody and paternity and criminal sentencing and many other type of things, services and domestic violence programs. I've had to take on many of these type of cases because it's rampant. We know not only that men get higher sentences for the same crime when all other factors are the same, including number of priors and family situation, but drunk drivers get higher sentences when they kill a woman than when they kill a man. And these are things that are documented but hardly talked about in academia or in government. And I know that's going beyond the scope of this case, but it's part of what this...
Do you now? Do you finally understand that's going beyond the scope of this case? These appeals to incredulity. Oh my God, do you finally recognize it's going beyond the scope of the case? Holy shit. Self-awareness. It happened. He became self-aware. Wow. Thank you. Thank you for figuring it out, you jackass. Jesus Christ.
The Supreme Court talks about bisexual stereotypes. We're sending a message, we're conditioning people to accept sex discrimination when it's against men. And that's why we hardly hear about these kind of things. And people who dare to speak up about it are called names, like misogynist or things like that, when all they're really asking for is equal rights. I would point out another thing, Your Honor. Even though the decision here, the standard of review is de novo, I would point out that the district court in this case did also make a number of factual findings that would fall under the clearly erroneous standard. One of them is that men and women are similarly situated with regard to the selective service. That is a factual finding. And others are that the selective service has provided no evidence to meet its burden of showing, for example, that women are less likely to enlist, that there would be less female enlistment, or that there would be some major trade-off if women are required to register for the draft. The district court also found that the decisions Congress made long ago about dependency and physical standards and hardship were not a studied choice. That's a factual finding. The district court found that Congress's biggest concern was women being banned from combat, and that's why they excluded women. Also, that Congress has been debating this issue since 1980 with no definite end in sight. Those are the words of the district.
Not that it really matters. But yes, they've been debating it since 1980, but the services have only been integrated since 2016. So, going back to 1980 and say, oh, they've been debating it since 1980 is a little bit disingenuous. Because it's not like they've been integrated since 1980. Not that it matters, but yes, Congress is debating it since the 80s. And they've become integrated, and they're debating it again as part of that process. I think my soul left my body at some point during the stream. I think that's what happened. Okay, let's press on.
Those are, I would argue, factual findings that go by a clearly erroneous standard. And as the court in U.S. versus Virginia said, a clearly erroneous standard, in order to be met, the error has to be so strong that it strikes the court like a 5-week-old dead unrefrigerated fish. It's a very strong standard that
What? What? It strikes you like a 5-week-old unrefrigerated fish, the attorney says. All right, I need to hear that again. Hold on. Excuse me 1 second. We gotta just crawl that back just a little bit here.
in sight. Those are the words of the district court. Those are, I would argue, factual findings that go by a clearly erroneous standard. And as the court in U.S. versus Virginia said, a clearly erroneous standard, in order to be met, the error has to be so strong that it strikes the court like a 5-week-old dead unrefrigerated.
I think we're set. Ms. Mario.
Congress is like a 5-week-old dead unrefrigerated fish. It's a very strong standard that has to be very clearly erroneous. And in this case, I don't think any of those findings, I think they're actually very good findings. And the district court made a very sound decision.
Five-week-old, dead, unrefrigerated fish. 5-week-old, dead, unrefrigerated fish. We've hit peak legal argument, people. We've hit peak legal argument. Ten out of 10. Argument of the year. Yeah, good. Great.
I would just add, finally, that we are talking here about both rights and responsibilities. And we have opened the door and given women the right to all combat roles, but coming with that is the responsibility to register if there is a draft. We take no position on whether there should or shouldn't be. Our position is that if there is one, and women are allowed in all combat roles, then there's no excuse for sex discrimination against men. So I would urge the court to uphold the district court's decision. Thank you.
All right, thank you, sir. Rebuttal.
Just, excuse me 1 second here.
Okay.
We have opened the door and given women the right to all combat roles, but coming with that is the very strong standard that has to be very clearly erroneous. And in this case, I don't think any of those findings, I think they're actually very good findings, and the district court made a very sound findings, and the district court made a very sound decision. As the court in U.S. versus Virginia said, a clearly erroneous standard, in order to be met, the error has to be so strong that it strikes the court like a 5-week-old dead unrefrigerated fish. It's a very strong standard that has to be very clearly erroneous, and in this case, I don't think any of those findings, I think they're actually very good findings. There is one, and women are allowed in all combat roles, then there's no excuse for sex discrimination against men. So I would urge the court to uphold the district court's decision. Thank you.
All right, thank you, sir. Rebuttal. Okay, when you started, I interrupted you by putting you to Roscoe right away, and you principally responded to me that one of the justifications for the court's holding may have changed, but the holding had not. So I ask you on rebuttal, having quick reread Roscoe up here at the bench, the claim was a due process challenge under the Fifth Amendment and not an equal protection challenge. So having heard what you said about the justification, my question is, because specifically framed in it was a Fifth Amendment due process argument of unconstitutionality and not 14th Amendment equal protection, does that matter?
No, Your Honor. The Equal Protection Clause doesn't apply against the federal government, and so under the sort of reverse incorporation theory of Bowling v. Sharp, in both in Roscoe and in this case, it was the Fifth Amendment due process clause was used to bring in claims sounding in equal protection. There's a footnote to that effect in Roscoe.
Right, and I only ask it because many of the cases cited, as you well know, in terms of the gender piece, derive or flow up from, the equal protection jurisprudence, et cetera, and just wanted to hear your response.
No, that's true, but certainly all of the military cases, with the exception of VMI, which I'll deal with in a second, with the exception of VMI, all of those military cases are cases about the federal government. So in all of those cases, it's an equal protection-like claim brought through the Fifth Amendment due process clause. So I think that's on all fours here.
Sorry to jump in. What would the application of rational basis review look like? I mean, in the economic realm, it's a giant anvil on the scale, very easy for government to meet its burden. What does it look like in the military realm?
So we think it looks very much like this. Now, obviously, the court did not want to call this rational basis, but it looks, when you look at those sort of main marks, which are, can you look at post hoc justifications, can you look at administrative burdens, how close does your tailoring have to be? It doesn't look, we think, a lot different than what happened in Roscoe or than what we're urging for
so long as
to apply.
So long as there's any conceivable, theoretical, hypothetical justification for the government's decision. And even if the government itself doesn't tee those up and assert them, judges are free themselves to sort of come up with on their own additional justifications they might find persuasive.
The only sort of limit I see there is just in that Schlesinger formulation. It says you look to what Congress may quite rationally have believed. So there is a sort of rationality requirement there, which is obviously in rational basis too. But and there could be some evaluation of reasons under that thought. Now in Roscoe, they are looking to what Congress said. I just want to maybe clear up one point, which is that the question of sort of like who else do we defer to if we're not deferring to the Pentagon? In this case, we are not deferring to the Pentagon. We are not deferring to the military. We are not deferring to the president. We are deferring to Congress. That's footnote 15 of Roscoe.
If we were to apply a heightened, again, Roscoe aside, if we were to apply a heightened, more muscular kind of judicial pat-down of all this, how does the government win?
So if you were to apply, full-fledged intermediate scrutiny,
Mhm.
like Craig Reborn style intermediate scrutiny, then I think we win, because what you should be looking at is the record that Congress has created, and that's what Roscoe did, right? In 1980.
No matter the vintage of that record.
Well, what I was going to say is in 1980, Congress creates a new record because there have been changed circumstances, and Rosker evaluates that record. That record is being created right now. So that's the Commission's report and Congress's reaction to it. And it's not really fair to hold Congress to what its justifications are when it's in the process of creating its record. Just a couple of quick points kind of in response. Agostini, in Agostini, the court does entertain a 60B motion, but it denies the 60B motion. So, the exact quote from the Supreme Court is, "The trial court acted within its discretion in entertaining the motion with supporting allegations, but it was also correct to recognize that the motion had to be denied unless and until this court reinterpreted the binding precedent." Similarly, in State Oil, the language cited by my friend goes to whether Scotus, whether the Supreme Court itself should apply stare decisis, whether lower courts should. In United States versus Virginia, I think it's important to distinguish that case because that's a state law case. So the Virginia Military Institute is a state institution. It was male only under state law. So there's no Congress to defer to there. It's not a case where under Article 1, Section 8, Congress has made some sort of judgment in support of its power to raise armies.
Let me ask you, one of the cases cited to it, or this came up, Council Officer Mayor, it was the Elizabeth Kyle LaBelle case, the female who challenged this in March of 2019, and the government of the other side filed a motion to dismiss a 12B6, and the district court allowed the claim, holding that she stated a claim, and it was similar arguments in terms of the due process, equal protection, et cetera, et cetera. Do you know the status of that case? Was it appealed to the Third Circuit? Is it sort of in the pipeline? So
as you say, a motion to dismiss was denied, but no summary judgment motions have been filed because they're currently doing class certification.
Oh, okay. It's still in the...
It's still in the district court,
gotcha.
and will be for some time.
Gotcha.
And just one final point, if I may,
Yeah,
which
go
is
ahead.
just that I think the district court would have been surprised to hear that it was making factual findings in the context of resolving a motion for summary judgment, where all facts have to be undisputed. Obviously, it would be reversible error to be making factual findings in that context, but the district court did not purport to be doing that. Thank you.
Okay, thank you. All right, thank you, counsel, for both sides. Obviously, a very interesting case, to put it mildly. Thank you for the briefing. I think there was an amicus, one or more amicus briefs filed, and good arguments on both sides. Obviously, you're both very knowledgeable of what's going on in the whole landscape of things. So we will take the case as submitted along with the other cases that were orally argued. We do have some other cases that were non-orally argued, but all those will be submitted to us. So this phase of this panel with me in it, that ends our cases, and so the panel reconstituted will resume tomorrow, but this panel stands adjourned. Thank you.
And we have opened the door and given women a strong standard that has to be very clear of the district court. Those are, I would argue, factual findings that go by a clearly erroneous standard. And as the court in U.S. versus Virginia said, a clearly erroneous standard, in order to be met, the error has to be so strong that it strikes the court like a 5-week-old dead unrefrigerated fish. It's a very strong standard that has to be very clearly erroneous. And in this case, I don't think any of those findings, I think they're actually very good findings. And the
Okay. Okay.
I would argue factual findings that go by a clearly erroneous standard. And as the court in U.S. versus Virginia said, a clearly erroneous standard, in order to be met, the error has to be so strong that it strikes the court like a 5-week-old dead unrefrigerated fish. It's a very
Okay. Well, that concludes our coverage of the case with women in the draft. So, yeah. Yeah. I think my brain stopped working. $5 from NATO, 200, who says it's you like a dead fish. 4 weeks. Yeah. The women, the decision's easy. It's compelled by a Supreme Court result. So, the legal result is super duper easy. Yeah. The U.S. government, the case will be reversed. I think I might have died. Is this hell? That would explain a lot. Okay. Well, until next time, I've been Uncivil Law. For those of you who've gotten this far, if you've not already done so, please hit the like button. Please hit the like button like a dead, unrefrigerated fish. Good night.